Hi there. This is an overview of filing a first-party claim under your own insurance. If you get hurt in a car accident, you may have to file a personal injury insurance claim against your own coverage, rather than against the other driver. A claim against your own insurance is referred to as a first-party claim. A claim against the other at-fault driver is referred to as a third-party claim. If you live in a no-fault state or Puerto Rico, you don't have a choice. You must file a claim with your own insurance company. There are 3 reasons for filing a first-party claim. 1. The at-fault driver was either underinsured or uninsured, and you have UIM coverage. 2. You have personal injury protection, PIP coverage, and don't have time to wait for an at-fault driver's insurance company to start paying your bills. And 3. You live in a no-fault insurance state or Puerto Rico and are required by law to do so. Now, there are pros and cons of first-party claims. Let's talk about the advantages first. You don't have to worry about whether you or the other driver was at fault. Your insurance company pays your claim regardless of who caused the accident. Your current medical bills are paid without having to negotiate the amount or argue responsibility with the claims adjuster. You're compensated for future medical bills related to the accident. Your out-of-pocket expenses are reimbursed, such as medications, crutches, etc. You receive your benefits promptly, compared to a third-party claim, which might take months, even years before settlement and payment. You have less stress, because a third-party claim is not an adversarial process. So it's the flip side of that coin. Let's talk about disadvantages. You may have to meet your deductible before your insurance company will start paying your medical bills and expenses. Depending on the state where you live, the maximum insurance benefit may not be very high. Many states set the maximum medical coverage under no fault or PIP at about 80% of the total, and the maximum for lost wages at only 60%. You may have to surrender your future rights to sue the at-fault driver to your insurance company. This is also known as waiving your right to subrogate. You may have to reimburse your insurance company if you receive any compensation from the at-fault driver or his insurance company. You may also have to reimburse your insurance company if you receive payments from your private medical health plan. In first-party personal injury claims, you can't get compensation for the pain and suffering or emotional distress you endured as a result of the accident. You're also prohibited from claiming punitive damages for intentional misconduct. So what are the steps to filing a first-party claim? Filing a first-party claim is very similar to filing a third-party claim. The same actions apply, from the moment of the accident up to contacting the insurance company. We've got 7 steps I want to talk about. The first step, stop immediately after the accident. In most states, failing to stop at the scene is a felony, punishable by time in prison. Second step, call 911 for police and emergency medical assistance. 3. Collect information. Write down the other driver's contact and insurance information, and the contact info of any passengers and witnesses. 4. Don't get into arguments about who was at fault. That will be determined later, when your insurance company investigates the accident. 5. Take photographs. Use a camera on your cell phone to take photos of the scene, any vehicle damage, and any visible injuries. 6. Ask the officer at the scene for the police report service number. And 7. Contact your auto insurance company and file your injury claim. Let's talk for a moment about claim notification and release of information. Your personal auto policy requires you to notify your insurance company after an accident. When you do, ask them to send you a follow-up letter confirming you've complied with the notification terms of your policy. Make sure they include the claim number for future reference. Your insurance company will require you to give a statement about the accident. They will also ask you to sign releases of information so they can collect and review your medical records. If you're claiming lost wages, they'll want to access your employment records as well. You must cooperate to keep your claim moving. Unlike a third-party claim, which can be adversarial, a first-party claim is designed to promote mutual cooperation between the insured and the insurer. The spirit of cooperation dictates you do what you can to help your insurance company resolve your claim. From time to time, we hear some unfortunate stories rooted in what we call bad faith actions. Your insurance company has a legal duty to act in good faith. This means if you file a claim and your insurance company gives you the runaround or refuses to cooperate in what you believe to be a valid claim, they may be acting in bad faith. If you think your insurance company is acting in bad faith, contact a personal injury attorney immediately. The circumstances require an attorney's legal expertise. In a customary first-party claim, punitive damages are not covered. This doesn't apply if you file a bad faith lawsuit against your insurance company. If you win, the court can not only force your insurance company to pay your rightful claim, it can also award a further amount as a penalty against the company for its bad behavior. There are potential arbitration and mediation circumstances and rights. If a first-party insurance claim can't be settled, the next step does not automatically have to be a lawsuit. Between a failed settlement negotiation and a lawsuit, your case can go to arbitration or mediation. Arbitration and mediation, collectively known as alternative dispute resolution or ADR, are other methods of settling your claim. If you and your insurance company are at a stalemate, you can ask them to participate in arbitration or mediation. In fact, many insurance contracts now include language requiring you to agree to arbitration in lieu of filing a lawsuit. Arbitration is normally binding, and the decision of the arbiter can't be appealed. You and your insurance company will be bound by the ruling. Mediation is normally not binding. The mediator's purpose is to bring both sides together and get them to agree on a settlement amount. If mediation fails, a lawsuit can still be filed. Insurance companies do not want to get involved in lawsuits with their insured. When faced with the possibility of a lawsuit, they'll likely agree to an alternate form of dispute resolution. If you and your insurance company agree to ADR, you can probably represent yourself. A final thought to consider on this topic is additional medical insurance. Before purchasing an auto insurance policy, it may be tempting to just take it and run and not read it, but you really should read every page carefully. Be especially aware of the language on the declaration page. Note if the amounts of the no-fault and PIP benefits are limited, and by how much. To ensure that you have enough coverage for an injury accident, you should decide if you need to purchase gap insurance or additional private medical insurance to cover those extra costs. Well, that wraps up our brief overview of filing a first-party claim under your own insurance. To learn more and get a free case review, visit injuryclaimcoach.com. Thanks so much for watching. Best of luck with your case.